welcome to Legally Speaking with me, Tarun. There are close to 28 million cases that are pending at various district courts across the country. There are well over 40 lakh cases which are pending at various high courts in the country. And what is the solution to cases which have been pending for as long as a decade? So years get lost, people get old, and the issue still remains where it is. People are fighting the cases in courts. Today, we are going to discuss what could be a possible solution to reduce the pendency of cases and solve this problem. To discuss this issue, we've got an eminent panel. I have got Advocate Varuna Bhandari. She is a mediator in the Supreme Court. I have got Dr. Vijay Kumar Singh. Mr. Singh is Head School of Corporate Law, Indian Institute of Corporate Affairs. We've got Anurup Omkar, an advocate who's into mediation, has written a book on the subject. And well, our most esteemed guest for today is His Lordship Arjan Kumar Sikri. And welcome, sir, to the show. And sir, if you could please give the opening comments on what is the solution to pendency of the issue of pendency.
You see, your question is very general, yes. And when we talk of pendency, then naturally there are so many ways we discuss to tackle this situation. We should have more judges, we should have proper case management and court management, etc. So I think for today's purpose, we are not going into all other ways by which these can be tackled, and yes. We are on alternate dispute resolution mechanism. That is, yes, when the courts are crowded with all these cases and it is becoming difficult for the courts to cope with this kind of pendency, whether alternate dispute mechanism can take some of the load off from the courts. So here, mediation is one. Arbitration is there. You see, arbitration is not court, so it's an adjudication by some person outside the legal system. And likewise, mediation is one such another form of alternate dispute resolution forms by which, if that becomes successful, that may go a long way in tackling these problems. I only give you one example of America. And this was the problem in America also in 70s. And when they started mediation. And today in America, 94 to 95% cases are settled through mediation. 94 to 95%, is that settled through mediation, and therefore there is hardly any burden on the courts.
Sir, I would like to know from you, since you have pioneered the concept of mediation in India, also when you were Justice of the Punjab and Haryana High Court. So could you tell us what has been India's success rate at mediation and what is the potential of mediation in India?
You see, as far as mediation itself is such a technique that it has large potential, very, very large potential. Because if I tell you in 1 minute what the mediation is a resolution of disputes by two parties who are disputing with each other when they themselves discuss what should be the proper solution for both of them. And mediator is a person who is an outside third neutral person who facilitates the discussion, the dialogue, the negotiations between the two parties. And one thing which is to be kept in mind is in the court in adjudicatory system, when a case is filed, the judge will decide either in favor of one party or the other party.
Yes.
And that is according to the judge, because that is, we call it adversarial system.
Yes.
So plaintiff has filed the case, he says, I have to claim this from the other side. The judge will say whether this claim is justified or not justified, or if justified, whether whole of it is justified or part of it is justified. But then there are many disputes where outside the court, if the parties settle between themselves and they think of settlement, then it is not only that one or two solutions.
Yes.
To any dispute, there would be variety of solutions. There may be 10, 15, 20 alternatives. And therefore the parties choose when they are made to discuss, they are made to dialogue, and the facilitator is their mediator who then which is the best solution, which is good for them. And it is called win-win situation, because it is a settlement which is ultimately arrived at by the parties to which both the parties have
I
agreed.
would want to take the opportunity now to ask you, now the millions of people who are watching this show now would want to know whether check bounce cases. Now check bounce is an issue, the Negotiable Instrument Act case as it's called legally is clogging the courts. Is there a solution in mediation to check bounce cases?
You see, I think for check bounce cases, mediation is the best alternative. For simple reason, in most of the first of all, let me start with this comment, that most of the cases, any types of cases, unless these are cases, we are not talking of criminal cases where somebody has murdered other person and all that, or some fraud cases, etc., which have to be decided by the courts. The cases of constitutional validity of a legislation, parties can't decide, it has to be decided by the court. But then, apart from these few types of cases, which may be exceptions, most of the cases are capable of settlement through mediation.
Most cases.
And the commercial cases are the best cases.
Commercial cases are
the best, where this check bouncing case may be a part of commercial transaction. So it may not be, but I'm presuming that it is also one of the facets of commercial disputes. Because one thing which is to be kept in mind is that in commercial field, or the businessmen, now of course nobody can say that disputes won't arise. In a society, disputes are bound to arise.
Yes.
So courts are there for settlement of those disputes.
Yes.
But then if the parties, every time when the dispute arises, whether it is in a family, whether it is between neighbors, whether it is between two partners, or any commercial dispute between seller and purchaser, first they will try that why not they settle themselves.
Yes.
This is the best mode.
Sir, before I get in Varuna and Anurup into the debate, I would like to ask you, could you give us one example of a mediated settlement, say especially in property matters? In Punjab and Haryana belt, due to the property boom, there were so many cases that happened. Could you give us at least an example, without of course taking names, of a mediated settlement which saved years of litigation?
I tell you, one case I'm reminded immediately, although it was a arbitration case. It was a dispute where a sister had dispute with her brothers.
Yes.
There was some cinema hall somewhere in Punjab where the father and his sons, they were partners in that cinema hall. It was a partnership firm, but he had inducted his daughter also as a partner. Daughter got married and went to US. And after the death of the father, the brothers were not giving share to the daughter. So she filed, because in the partnership agreement, there was a clause of arbitration. So she filed a petition for appointment of arbitrator.
Okay.
And that came before me. So and she had come from America. On that day, it was listed for arguments. So she wanted arbitrator to be appointed because of this, that disputes are there. So I asked her that, look, even if I appoint the arbitrator will then start the proceedings.
Yes.
It will start, it may take some time, then arbitrator will give the award. Even if that award is in your favor, ultimately other side can challenge that award in the court. So another inning would start in the district court, high court, Supreme Court. So it will take so many years. Would you like to that I send it for mediation and let us explore the possibility of settlement? She said that I am here only for 1 week. After 1 week, I am going back to America. I said, okay, no problem. I'll fix the hearing tomorrow itself. That was Friday, because Fridays we take up these matters, arbitration matters, the Chief Justice takes. So Saturday I sent to the mediation, High Court, Punjab and Haryana High Court Mediation Center. And next week I kept, because next Friday I kept with me. And next Friday, I received the report that the matter was settled on Saturday.
Sir, this itself is a news, a civil matter getting settled in 5 days?
Yes. No, it settled in 1 day. Before me, it was after 5 days. Okay. And I tell you, at the end of the day, she was very happy. Next week, she appeared. She said that, look, I had come for appointment of an arbitrator. Then the dispute would have started, adjudication, etc. I have been given my share according to my satisfaction. And I am going back. So we thought that not only this dispute is settled, she becomes our ambassador. when she goes back to America, she'll say, no, Indian judicial system is not that bad.
Yes.
Not those kinds of delays. Look, in 1 week I have got even everything
Justice
which
Sikri,
I
I
wanted.
would want to get your opinion. Civil matters in India, and we all know it takes 10 years, 12 years, 15 years to settle. You saying it got settled within a week. In fact, it got settled within a day.
Yes.
So,
Look, I really appreciate that mediator who started sitting at 11 and it went up to
so do you think
11 in the night.
There is not much awareness on this? Otherwise, a lot of
Yes, actually, you see that to encourage the mediation, there are various steps which are taken, and we have been. But one main thing is, as you have rightly pointed out, awareness is to be there.
Yes.
Where people, when they come to know that yes, there is such a mechanism, and it can be sent there, and it is so. It's not only cheap; it is so. Expedient also, and if the dispute is settled, it will. So it is cheap, time effective also, and what else is required?
So now, before we discuss billion-dollar disputes, and we are speaking just before the Global Pound Conference, India chapter is going to be held, I'll go to Anurup Omkar. Anurup, you've written a book on the subject of mediation, and Sir just pointed out 94% of cases in the United States are settled via mediation. What is the situation in India? Quickly, if you could tell me.
See, in India, as Sir rightly pointed out, there is lack of awareness. So presently the success rate is somewhere between 60 to 70%. But in certain states it varies, like settlement in Delhi, settlement in Bangalore, settlement in Bombay, where the awareness is high, not because the judiciary or the legislature has taken a step forward mediating the matters, but there are chamber of commerces which have come up with their own mediation centers.
So it is gaining acceptance.
Exactly, right?
Did you write a book because you wanted people to get aware on the subject? Was that the intention?
Yeah, that was typically the intention, because I had done mediation for 4 years then. I realized, lot many people don't know about mediation, and what they view mediation is only that can be used as a mechanism in matrimonial disputes.
Okay.
But if you have famously heard of the Samsung and the Apple dispute in Europe, there was a dispute based on the patenting of the edges between Apple and Samsung. So it was mediated, and nobody knows who the mediator was, but the solution that came out.
So you mean it has immense potential?
Immense.
Okay, I'm going to Varuna Bhandari. Ma'am, you have mediated settlements in the Supreme Court. Do you see acceptance of mediation as a form of settlement, since you practice at the Supreme Court on this subject?
In Supreme Court, most of the matters which are referred by the courts are transfer petitions in matrimonial matters, and there are some commercial matters which are also being referred. In matrimonial matters, the parties are a bit hardened, and it takes some time to neutralize the situation and then get them
matrimonial disputes can be settled by mediation, and harassment cases, dowry cases.
Absolutely. There have been matters. There is.
I'll only add, settlement rate is quite high.
Is it high? Quite high?
Extremely high.
So you mean, sir, all cases related to 498A, which we call harassment by in-laws?
Dowry demands, etc., harassment, cruelty to, and harassment because of demand of dowry. That is 498A.
So would you advise a lot of litigants to go in for mediation in such cases?
There are. Actually, I tell you what she pointed out. This is petition in the Supreme Court comes, it's a transfer petition only. That should be transferred from one place to other. We send for mediation. And when the case is settled, which I said the rate of settlement is quite high when it is sent to Supreme Court Mediation Center, thanks to mediators like her. But then it is not one case which is settled, 4 or 5 cases, because between the parties we see there's a case for, say, divorce filed by one party against other, there's a case for conjugal rights filed, there may be a case for maintenance filed, case for dowry, 498
so, what
filed,
you're saying, what
and
you take
sometimes
years.
property disputes all get one, if in one settlement, 5-6 cases get settled.
This is a very win-win or magical solution for reducing pendency in a...
Yes, exactly.
Okay. So now, before we discuss the issue of billion-dollar disputes, I'll take a short break on Legally Speaking, and we'll be right back. Welcome back. Now we'll discuss the issue of acceptance in the judicial community or judges of the mediation as a what you can say instrument of settlement, and can these billion-dollar disputes, because India is growing at a rate of 7% and disputes are common. So I'll first talk to Dr. Vijay Kumar Singh, sir. You have in the institute that you work, you've interact with a lot of judges, and do you see acceptance among the judicial community of mediation as a form of settlement, or because India, what you can say, still to catch up, as Justice Sikri sir pointed out, what do you see of acceptance on this issue?
As far as acceptance is concerned, definitely there is an acceptance to an extent, but the acceptance level is not that much in the commercial disputes, if you want to say, because it is a new law which has come up, and I believe the government is very conscious about it, and it came up with the Companies Act 2013.
Yes.
And in that particular act, there is a specific provision which provides for
So there's a specific provision in the Companies Act 2013
for maintaining a mediation and conciliation panel.
Yes.
And now in every area there is a mediation and conciliation panel maintained by the regional directors of the companies.
All the NCLTs have a panel.
So
Okay.
now the National Company Law Tribunals, which will be actually dealing with these commercial
But I
disputes.
want to ask you, Justice Sikri just pointed out that 94% cases in the United States of America are settled through mediation. Do you think we've got a long way to go, because we would have been
In commercial disputes, definitely yes. But but we are very hopeful, because in that particular area a lot of work is being done. There are already empaneled mediators on this particular thing, though the cases are yet to be referred, but
Yes.
definitely
You
we
see a
look
lot of
forward.
potential of
lot of potential,
but-
definitely.
I would
I'll
like-
add only this much, that look, the commercial world may not be knowing much.
Yes.
But lawyers know.
Lawyers.
Not today, as far as awareness among lawyers is concerned, it has, there is
So you think all lawyers know of mediation?
Yeah, almost
Yeah,
all.
definitely.
And
Yes.
I tell you one thing, only say 10, 12 years ago, 2005, when first mediation center was started in T. Sarari district as a pilot project by the Supreme Court, there was lot of resistance by the lawyers. What is this? And I say, I always use this expression, this is ADR.
Yes.
So lawyers perceived it as alarming drop in revenue, as if
that's a
their
good one.
earning is going to be. So therefore they resisted. But today,
Yes.
there's so much of acceptability, and the lawyers have understood, particularly in these cities where the mediation is now taking off at a great pace. They have understood. They come to us and they say, they themselves demand, let it be sent to.
Sir, I would
them.
like to
So they can be our good ambassadors to the commercial community.
So
And
do you
if
think
they
lawyers
start
have a responsibility to spread mediation as a form of
Yes.
settlement to help the courts reduce pendency?
That's right.
So it's a
That's
lawyer's
right.
responsibility.
Yes.
They should be doing the
Yes.
talking.
And another good thing is that lawyers should know, and they know it now,
Yes.
that mostly the mediators are lawyers. So it is another dimension of practice for them. So their earnings are going to increase, not reduce.
So that is an opportunity too.
Yes.
So it's a win-win for all.
Like in US, you have mediation councils, just the way you call arbitration council. Mediation in US has developed to such an extent. Lawyers represent their council.
No, but sir said it's 94%, so I well understand that
No,
it's
in
an
fact-
established practice.
Yeah, yeah.
In fact, you referred to Global Pound Conference, and if you
Yes.
see the last report, in fact the first report which was held in Singapore, you will find that the first point of contact is a lawyer, because somebody like a commercial man, where does he go?
Right.
He goes for alternatives
Because
to the lawyer.
Sir, when I'll get Justice Sikri into the discussion now, sir. When we talk of India, there are millions of small traders. They are busy in their own businesses. When they have a dispute, they don't know anything like mediation. They just know how to get hold of a lawyer, and they go by whatever he says.
Exactly.
So wherein awareness also comes. Awareness is one thing, sir, but one thing I would like to ask you is, there are billion-dollar disputes, because India is growing at such a fast pace, and you've got these big disputes which have implications of hundreds of thousands of crores. Now these disputes are between government and the Ministry of Road Transport and Highways, government and so many other ministries, government or private party to private party. They take years in courts, and they say that companies can't pay their loans because money is stuck in disputes. So banks become NPAs. Banks suffer, their employees, so the whole economy suffers. So do you think there is a strong case for such cases going to mediation?
Actually, strong case, I think these are the, as I said earlier also, the best alternative for them is the mediation. Because a businessman doesn't want that the cases are stuck in the courts, and these are various kinds of other effects which you have yourself said. And therefore, as I said, disputes would arise, but a businessman, commercial world wants that the dispute should be settled as early as possible. And there's another very important thing into it. That is, in the entire mediation process, there is a confidentiality.
Yes.
What happens in mediation, suppose mediation ultimately fails, it's not that every case would result in success. The parties still may not agree, they will have to go to court if they don't agree.
Yes.
But then, whatever happened during mediation and whatever, it's all confidential. It cannot even be asked by the court that as to what happened.
So the court doesn't ask.
So therefore, that is an added
Sir, is it
charm
built into
for the commercial world, because when it is all confidential, many times they don't want.
So secrecy is mandated by law in mediation?
Yes.
Okay.
Yes.
Okay.
That is one of the fundamental principles of mediation.
It's confidentiality.
The confidential.
One more thing I'll just add on, which would be interesting for your $1 billion, those clients who are interested. People have this apprehension that they cannot continue litigation, arbitration alongside mediation. But the interesting fact which they would like to know, you can litigate simultaneously, mediate. You can run it parallelly, and in case you manage to settle it, you can get the refund of the entire court fees, which is alarming when it comes to $1 billion dispute.
This happens? Do you see people going parallelly in for mediation and litigation, as Anurup just highlighted?
Yeah, absolutely. Tarun, I will add another thing. When I started mediating, and when parties used to come to my office, I used to ask them, do you think we can settle it another way? There is something called mediation. Can we call the other side?
Yes.
Invariably, they would say, no, they will not come. Then I would request them, let us give it a shot before we start litigation. So, an invite was sent to the other side, and to come with their own lawyer.
Yes.
And as we say, there is an opening statement that we make, and opening statement was made to the both the parties, and asked if it can be matter should be referred to mediation. Let me tell you, many cases I settled like this in mediation.
So people do agree.
Yeah, yes.
I'll go across to Justice Sikri at this moment. Sir, when we spoke of cases involving business parties, now there is a view that cases which are filed against the government, where contractors don't get their due, or there is a problem of settling those cases. Do you think it's only private party to private party cases that can be resolved through mediation, or cases where government as a party can also be resolved?
Where government is a party can also be resolved.
So that's
There's
also
no problem.
into.
And there are many times these are with government bodies, particularly, actually we have two kinds of mediation, we can say. One is court annexed mediation.
Yes.
That is where the case is already in the court,
Yes.
but the judge sends this for mediation.
Yes.
Other is out of court mediation, where before going to the court, you go for mediation. Second type of system has not started in India.
Yes.
It's taking off
Yes.
now. But then the first is there, where the courts keep on referring the matter for arbitration.
Yes.
So therefore, there they refer even those matters where the party is a government. The only problem is, on the one hand, the government is keen and very enthusiastic in this, that the mediation should be, we should be made aware and it should be explored and all that. But when it comes to the government departments, and in a particular case, many times they are reluctant in settling because of various other things. So suppose I settle, because it's ultimately a settlement.
Yes.
Tomorrow there may not be CVC after me, there may not be...
So do you think bureaucrats need to be, what you can say, there should be a safety layer around them also, that if they come forward to help with mediation, they shouldn't be victimized?
Exactly. No, I tell you, for just in the beginning, and when I was in Delhi High Court, and we used to have, I was in that committee of mediation, we used to have these programs, mediation training programs. Once we had a training only for these from public sector undertakings, their CEOs or those who were on legal side, and we had called CVC also.
You called CVC also?
At that time, so that when these cases are settled, and CVC also gave them assurance at that time. But still, many times there is a lurking fear.
Okay.
But
what I can see, sir, is that a huge potential for mediation.
Yes, yes.
On this count, we call a close of our first edition, where we discussed mediation as an instrument of reducing pendency of cases in the country. But thank you so much for joining us on Legally Speaking. All of you, thank you so much. We come back right back in the next episode to discuss the whole issue of how mediation can solve this problem, a step-by-step approach. Thank you so much for joining us.